You're accused of a crime, and naturally, you want to know what the evidence is. But in Allen County, your ability to see the evidence at your convenience will likely be restricted. Most defendants might not care, but does that make it right? Well, we ask that question tonight. And how active are you allowed to be in your own defense? We examined both sides in this 15 Finds Out special report, Justice by Appointment.
It was June 30th, so Sunday night. Two brothers had a dispute. I was just charged with opening a door that touched him.
Police came to Jeff Williams' home after he had a dispute with his brother. They charged him with misdemeanor domestic battery and disorderly conduct for unreasonable noise. Those charges were dismissed unconditionally because he knew the police report was different from what actually happened. But during the 8 months of fighting to clear his name, he learned he was not allowed to examine the evidence at his home.
I was surprised to find out that I'm not allowed to have any of the evidence. I can go view it, but I can't have it.
For the last decade, the Allen County Prosecutor has asked defense lawyers to sign an agreement to keep discovery evidence in their defense lawyer office and not share it with their clients, fearing those clients might put the evidence online. Mike McAlexander is the Allen County Prosecutor.
So it's trying to walk that line between the privacy and the confidentiality for victims and for some sensitive information that we have, while also complying with the discovery rules and being able to give the defense everything that they should have. It's not a perfect system, but it was our way to try to keep stuff out of the public domain where it didn't need to be. But it's doing that balance between protecting the victim and allowing the defendant to have all the information that's available.
What I'm told is, though, Allen County does this differently. In other counties, it's more of a case-by-case protective order on individual items, like we would just redact the names of the witnesses, but not allowing the defendant to possess it, not publish it, but just even possess it, seems a step farther than anyone else.
I think it's probably due to our volume.
There's nothing wrong with our Allen County Prosecutor's Office. They're honest people.
Right.
They're honest people.
Defense lawyer Richard Thonert says he's litigated everything from speeding tickets to murder. He says most clients are okay just coming to the office.
Is there a particular case where someone who is accused of a crime where it's very, very critical that they have everything and they'd be able to take it home, go through it, think about it, have other people look at it, maybe give opinions, things like that, or even if they want to see another attorney and get a second opinion. If you sign this letter and you come into your attorney's office and say, you know, I've listened to what you've had to tell me, but I think I'd like to get a second opinion. Give me my file. I want to take it to this other attorney. You can't do that if you sign that letter. That file would have to go back or get the prosecutor's permission to do it.
But that permission might not come easy. When Thonert was directed by a client not to sign the letter, the response from then prosecutor Karen Richards seemed to show not signing was rare. Quote, "You are the only attorney in Allen County who will not sign our discovery letter. Every other defense attorney has agreed to these terms, and discovery is provided pursuant to our letter. The above has been the long-standing policy of our office and is in response to several incidents of defense counsel, the defendant, or defense witnesses posting it to social media."
Maybe Fort Wayne, Indiana is different and everybody's on Facebook and there's all kinds of jury tampering involved. My guess is that this is a remedy that is addressing something, an illness that hardly ever occurs.
That's Chris Wellborn, president of the National Association of Criminal Defense Lawyers.
So clients need to be able to see the evidence sometimes, and that's just the reality of it, because it's the client who makes the decision. Are we going to trial or are we not going to trial? Am I going to take this offer or am I not going to take the offer?
I'm the expert on being there. My attorney is the expert in the law. So defending yourself is a true partnership between the two. To this day, every time I read that probable cause affidavit, or what they call PC, probable cause, I notice something different. I don't need to just have an appointment to go look at it. I need to have it where I can look at it, put it down, look at it the next day, take notes, maybe Google something, right?
Somebody just said this is like kind of justice by appointment. That I have to come downtown, all those things.
Yes, that is true to a certain extent. But that's really between them and their lawyer and how they want to do that. But it also gets into the practicalities of it. Obviously, to the defendant, they're only worried about one case, theirs. Everybody else in the system is juggling a lot of different things. But the danger of giving them everything all the time is you're going to see that all over the place.
Now, as best we can tell, no other Indiana County Prosecutor's Office uses this blanket approach. However, the entire state of Texas does. And the phrase justice by appointment comes from an Indiana Supreme Court reversal when Richard Thonert, after he didn't sign the letter, was forced to go to the prosecutor's office to view evidence. The court said Allen County should not limit discovery in that way for defense lawyers, but it's never addressed if it's allowed for defendants. There's so much more to read on Wane.com, including the cost to Jeff for his defense and how he used a different method to find much but not all of the evidence in his case, despite what officials wanted.